Hi, everyone. Thank you for joining us today for this week's episode of Trump's Trials and Tribulations. My name's Anna Hickey. I'm an associate editor here at Lawfare, and today I'm joined by Lawfare editor-in-chief. Sorry about that. Today I am joined by Lawfare editor-in-chief Benjamin Wittes and senior editor Quinta Jurecic. So
Hey,
it's been a pretty slow week in, Trump trial news this week. So if you're joining us on Zoom, please make sure to get your questions in earlier than normal at around 4:45. And if you're joining us on YouTube and you'd like to be able to watch this live stream without ads and submit questions to our panelists, you can become a Lawfare Material supporter at lawfaremedia.org/support. So, Ben, to kick us started, has anything new happened in New York since the conviction?
well, not much, but I guess the main action has been that Congress has gotten involved and is demanding and apparently going to get testimony from Alvin Bragg and from Matthew Colangelo, who was one of the lead prosecutors on the case, and importantly, from the Republican congressional perspective, was previously serving in the Justice Department, and therefore may be the missing link between the New York case and uh, uh, evil manipulations by the Biden administration generally and Joe Biden in particular. And so I believe that is scheduled now, and they have agreed to testify. Um, I'm count me a little bit skeptical that this is going to work well for Jim Jordan and company. These are very polished trial lawyers, which make for the worst kind of witnesses, which is to say, they're used to dealing with hostile witnesses, they're used to dealing with opposing counsel, they're used to dealing with angry judges. And Jim Jordan, other than the wild gesticulations and constant references to Peter Strzok and Lisa Page, actually doesn't really know how to ask a question very well. And so this seems like the kind of thing to me that looks sort of scary and newsworthy, but what it'll end up being is Jim Jordan shouting a lot and Alvin Bragg and Colangelo repeating somewhat robotically, we made this decision based on the facts and the law, and we proved a case to a jury beyond a reasonable doubt, and it's still a pending matter, so we're not prepared to comment on blah, 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 and blah, blah, blah. So I suspect it will end up being relatively sort of mountain and molehill kind of thing, but you never know. Anytime you have a significant congressional showdown, there's always a chance that, somebody will uh, make news somehow.
And then thinking about the fact that the case is still ongoing, we have appellate issues that may come up. We had an article up in Lawfare earlier today by a law professor, Lee Korvarski. Quinta, can you talk about what Korvarski talked about in his article?
Yeah, so this is an article by Lee Kowarski, who's at the University of Texas in Texas Austin, and Anna can put a link in the chat. I think it's a really useful overview of some of the uh, misrepresentations of law, let's say, that have popped up on the political right and among the sort of commentariat, walking through the many ways in which Justice Merchan's rulings were really very run-of-the-mill and sort of uninteresting, not really a subject on which Trump might do well on appeal. Um, and then also the fact that, Trump really is not in a particularly strong place when it comes to appeals, despite some of the suggestions. So there's a variety of things that Lee goes into. A number of them were sort of, I think it's fair to say, debunked at an earlier stage, but it's worth addressing them here. So, one of them is this idea that Trump, didn't know what he was really charged with because the counts were felony counts elevated to, or excuse me, misdemeanor counts elevated to a felony, being linked to another crime. And there's this kind of line on the right that, they didn't know what the other crime was. As Lee points out, that's just flatly not true. And he goes through in some detail. There's also arguments about, whether or not Trump could argue that he was the victim of selected prosecution. Whether or not you accept that argument, as Lee points out, the standard in New York for that is pretty high. And so it's sort of not particularly likely that that will do well either. I think that I don't think I'm speaking for Lee when I say that the aspect of the case that may be most vulnerable on appeal has to do with some of the unlawful means that created the election conspiracy offense that allowed the DA to bump the business records offense up to a felony. There's some specifics which I won't go into here, but this sort of raises questions about whether or not those were legally and factually sufficient. We won't, of course, know any of this for a while. Trump's sentencing is scheduled for July 11th, the day before Bragg and Colangelo are scheduled to appear in Congress. And of course, he's only going to be able to file his appeal after that. But I think Lee's article is a good kind of preview of some of the arguments that we might be seeing going forward.
And then, Ben, anything else to add on New York before we start making our way down south to DC?
Well, yeah, the other thing that happened, of course, was that Donald Trump met with his probation officer, and I do want to admit that I've really just enjoyed saying those words. That was a fun sentence to say. He apparently did it remotely, and he did it with his attorney. Those are both accommodations to the circumstance. Somebody said on the chat just now that it would be fun to be a fly on the wall of that meeting. I agree. I was thinking of ways to use, the hide non-speaking participants to sort of crash their Zoom meeting. But no, that would violate various rules, and I wouldn't do that.
Can I make one point about the probation?
Yes, please.
I mean, I do think it's worth noting, for all of Trump's complaints about how he's being persecuted, there are so many ways in which he's really being treated with velvet gloves by the legal system. And the fact that he is able to meet with his probation officer remotely rather than coming into the office, the fact that he was able to do so with a lawyer, I think are excellent examples of that. I will say that I saw folks who are defense lawyers in New York State comment, I basically, maybe I can point to this case to try to show up myself to, my clients' probation interviews. I think that whatever your position is on the matter of criminal justice reform, it is worth underlying the ways in which Trump is being treated, especially here.
Yeah, so I agree with that, although I actually don't mind if Trump gets treated differently. I think there are legitimate reasons to do that, including the Secret Service's many equities about every time you have to get him into that building, you have to cause huge traffic jams, you have to secure a building that's full of felons. So, I mean, I think there's plenty of reasons, legitimate reasons to treat him separately, differently. That said, I think we should note every single one of them, often repeatedly, because of the disinformation that he is promulgating, that he is subject to some double standard in the other direction. And I think it is worth giving him these accommodations, but it is also worth being very direct and public about it, that we know this is happening, and this is not a situation where he is being treated less than, but much greater than the average defendant. The point I was going to make was, we are in the sentencing process here now, most of which is invisible. The part that presumably won't be invisible is the sentencing briefs filed by both sides. And, Quinta and I were talking the other day about what the universe of potentially comparable cases looks like. Everybody assumes it's extremely small, if there are any at all. Quinta found a really interesting case in which somebody was convicted at trial, like Trump, only for false records in the first degree. But the problem was that these were gun purchases. And the guns were used not by her, but by somebody else, actually to kill people. And so this person got prison time. There's some similarities, but it's a very violent adjacent felony, and it's violent adjacent in a fashion in which people actually died. So, one of the big questions that we're going to be all looking at is, what do both sides come up with in terms of their supposedly comparable cases, and what do those suggest? Are there cases in which somebody goes to trial with a case with this as the lead charge, takes the state through time and expense of trial, and then does no jail time? Are there cases in which, conversely, there are the kind of aggravating factors that exist here, that is total unrepentance, total contempt for the court on multiple occasions, a finding of contempt, and then but also have no prior criminal record, right? And so you're dealing with a very, very specialized set of circumstances here, even before you get to the fact that this is a presidential candidate of a major party. And so I'm really, really interested to see the sentencing briefs, and to see what the cases that they cite look like.
Sorry, I muted myself. Just to add in there, so the case that Ben is referencing there is People v. Nguyen, Nguyen. And in that case, the defendant, Don Nguyen, who was convicted at trial of one count of 17510, the felony business record statute, was sentenced to a full 4 years. But as Ben says, that is a very different case in terms of, the actual underlying facts. She was a straw purchaser for a firearm that was used to kill people. So it's a bit different. I think it's also worth saying, I think it's hard to say, because there are plenty of examples that the district attorney's office has pointed to in the briefings and the filings over the course of this case, of other instances in which 17510 was charged. But most of those either have an object offense, the crime that moves it from a misdemeanor to a felony, charged along with it, which this one does not. That's why the Nguyen case is a useful comparison, because Nguyen was charged only with 17510. And it's also worth saying that, most of the cases in which this is charged, the defendant pleads out. Just as a fact of the way that the legal system works currently in the United States, is that the vast, vast majority, over 95% of defendants plead out. On the federal level, I think it's comparable in New York State, although I don't have the precise figure. So, there's often people describe a sort of a penalty, like a trial penalty for, you get a bigger sentence if you go to trial rather than if you plead. So in this instance, it's just hard to compare those sentencings from plea deals compared to trials.
And then when those sentencing documents become public, you will all be able to find them on Lawfare's docket watch, which is at lawfaremedia.org. So now hopping on I-95 and heading down south to DC, Quinta, has there been any updates or news in the DC case that Jack Smith has brought against Donald Trump?
So we are still waiting on the Supreme Court every day. So the court typically lets out at the end of June. The justices have kind of a self-imposed deadline to get out of town and go on their vacations. So every decision day in June, we're all kind of, waiting with bated breath. We had one today. We did not get the immunity opinion or Fisher, the opinion that concerns the obstruction of justice statute. We do have an opinion day on the calendar for tomorrow. That's unusual. So we'll see if we get anything then. And then I believe currently the only thing that is on the calendar is scheduled after that is on June 20th. But there's a hefty amount of cases left. The court has been slow this term. And so I think we have, it's like 27 or 28 remaining. It's a hefty number. So it's with that in mind, it's kind of hard to work out just when we might get that opinion. I will note that though the court usually does not go past the end of June, I think there was a time a couple years ago where they did go into the beginning of July. So I suppose that's possible if they're really running up against a deadline.
And then just for listeners' awareness, tomorrow after the opinions are given, a Supreme Court official will announce when the next, court in session day will be. So tomorrow around 11 o'clock, we'll probably have a better idea of when the next, day we may get an order. Ben, any other thoughts on waiting on the Supreme Court to give their ruling on Fisher or the immunity case?
Yeah, no, I mean, nothing substantial, merely that, when those two cases come down and everybody's focused like a laser on the immunity question, but the Fisher case, which is, as longtime viewers of Trump trials and tribulations or listeners know, the Fisher case is also highly salient to it because it involves the statute 18 U.S.C. 1512 C2, under which two of the charges in the case are brought, and it could substantially narrow the case. So, I mean, look, what's going to happen is that you're going to have a very quick study of those cases by the special counsel's office. And then they are going to make a decision about whether, first of all, whether they need to narrow the case in order to proceed with it, which I suspect they will. Second, whether some substantial portion of the case is affected by whatever degree of immunity the Supreme Court recognizes. And then you will get, I think, a relatively quick move from the special counsel's office to try to get the case moving again. And that will involve going back to the district court and saying, okay, we're dropping this charge. We're striking these paragraphs from the indictment. Now, could you set a trial date for next Tuesday, please? And, Trump will come in and say, no, next Tuesday doesn't work. How about never? Does never work for you? And we'll all make jokes about that New Yorker cartoon and expect that to happen all in the first week or two of July.
So now moving to another case where lower court proceedings have been stayed in Fulton County. Ben, can you give us your best Anna Bauer impression and update us on everything that's been going on in Fulton County?
Okay, so first of all, I am in my palatial mansion. I'm in the hanging hammock room. And you have to imagine that I am Anna Bauer. Which so look, I mean, Fulton County is stayed in a way that neither of the other two cases are stayed. The We have in South Florida, notionally the case is moving forward. We have a judge who is throwing every roadblock in the way, but briefs are being filed, briefs are being argued. She's issuing rulings every few months. And of course in DC, we have a case that's completely stayed, but we sort of know what the end date of the stay is, right? Because the Supreme Court generally does finish its business every year, and presumably by the beginning of July, we will have a ruling that will answer the question. But Fulton County is now like stayed. The Georgia Court of Appeals has a case that an appeal that they are not expediting. It will not be argued until October, I believe, is when the tentative argument date is. And then they will take exactly as long as they feel like to resolve it. And so that is, and they have slapped a stay on the 8 defendants, the case, at least as to the 8 defendants who are party to this appeal and the motion that underlies it, so that Judge McAfee, however efficient he may want to be, can't do any work on that. So the only thing that's happened over the last week or two is that one of the defendants, Misty Hampton, who is not party to that motion, put up her hand and said to Judge McAfee, "Me too. Can't the stay that applies to everybody who is party to that appeal apply as well to the 6 defendants who are not?" And Judge McAfee said no, and denied that. And so what looks like it is happening, maybe, is that the 6 non-appealing defendants are now to one degree or another on their own, and you could have movement in the case vis-a-vis them, but not the 8 who are subject to the who are appealing. And so it may be the beginning of a fracture in the case, in which one group goes ahead and they try it once, and the other group gets a break for however many months it takes the Georgia Court of Appeals to resolve this.
And I also just want to mention that the state's DA Fani Willis and her office have filed a motion in the Court of Appeals to dismiss the appeal as improvidently granted. Whether the Court of Appeals grants that motion, as they have already, declared a potential hearing day, is,
Yeah,
a little ambiguous.
I just want to say that in the highest profile matters, courts of appeals don't tend to say, "Nah, we screwed up." Forget that one.
And then, Quinta, anything to add on Fulton County before we check in on Judge Cannon?
I will definitely recommend watching Nathan Wade's interview on CNN with Caitlin Collins if you enjoy secondhand embarrassment, because that was one of the most cringy things I have ever seen.
So I have
shielding myself with my hands.
Wait, you're gonna have to now dish about it, because I haven't watched it, and this is the first I've heard about it.
Oh yeah, no, he went on CNN. There's a bizarre moment. He sort of just, puts forward word salad. There's a point where Collins asks him basically for the timeline of his relationship with Willis. He starts to answer in what sounds like a very vague non-answer, and then says, "Oh, I'm getting signaled." His, what I assume are like communications team, comes over, moves him into the corner, and has sort of a huddled conversation. CNN still has the cameras rolling. after maybe like a minute and a half, he comes back and sits down, Canton called and says, "Everything all right?" And she's like, "Yeah." And then proceeds to give a total non-answer to her question. And also says that the whole thing is a distraction, which I think really raises the question of why he's on CNN at all. So it did not reassure me as to his judgment. Let's put it that way.
Reminder to everyone, if the whole thing is a distraction, stop going on national television to talk about it, whatever it may be in your life.
And now moving to see what Judge Cannon is up to in Florida, where we have gotten some motions. Ben, can you talk about Judge Cannon's recent order?
Yeah, so Judge Cannon actually issued an order, or Roger would correct me and say she issues lots of orders, but this is a written opinion, and it's a written opinion denying something that Donald Trump asked her to do, which was to dismiss the case on the basis of a variety of factors, duplicativeness, surplusage, etc. And all of that would sound like very good news for the government, except that there are a couple of poison pills in the opinion. One of them, I think, is comparatively unimportant, which is the one that has grabbed all the attention, which is that she struck from the indictment a particular paragraph, which is one in which Donald Trump, former president at this stage, shows a classified document to an aide and sort of announces, "You're not supposed to see this, but, blah, blah, blah." I think like the part of the opinion in which she does this is pretty hard to justify, but I also don't think it matters very much for a variety of reasons we can talk about. The government can still probably can still present evidence about this matter. So that's the one that got all the attention. If you look at the press coverage of it, Cannon denies motion to dismiss, but strikes paragraph allegation from the indictment. The part that I actually thought was much more significant is the following, which appears on page 7 of the 14-page opinion. It's written in her usual impenetrable, just terrible writing style. But it says, count 36 is structured similarly, all in the context of section 1519. In this way, neither count charges more than one crime, although given the pleading format, there likely will be a need for clear prompts and separate verdict forms requiring the jury to unanimously determine which means, if any, each of the two defendants charged in count 34 and 36 used to commit the alleged crime. Now, I am not an expert on criminal procedure, and I don't want to pretend to be, but this jumped out at me as weird because as a general matter, it is black letter law that you do not, as a prosecutor, have to convince a jury unanimously which means are used to commit a crime. You have to convince a jury unanimously that the elements of the crime are satisfied. But if the charge is that Anna Hickey murdered Quinta Jurecic, and some jurors believe, they all agree that she murdered Quinta, but some believe that she did it with a knife, and some believe that she did it with a pick, sort of Trotsky style. That's not a distinction, that's not a matter on which the jury needs to be unanimous. And so I was struck by this, and I suspect, although again, I'm not an expert on this. I suspect it is sort of another means that Canon is kind of building into jury instructions, or sort of promising to build into jury instructions, these little Easter eggs for Donald Trump. And this one, at least as best as I can tell, is sort of flatly contrary to law. Um, uh, and again, it's not obvious what you can do about it as the government, because once you have a jury impaneled and she issues a jury instruction like this, once the jury is impaneled, double jeopardy kicks in. And so I suspect this is at the special counsel's office being taken as something of a Pyrrhic victory. But I don't know, and I would defer to people who know, Crim Pro better than I do.
And Quinta, did you have any reaction to Judge Cannon's, order partially denying Trump's motion to dismiss?
Nothing much. I think I'm pretty much where Ben is. I mean, the irony is that I'm now super up to speed on constitutional requirements for jury unanimity because of the New York case. So for the same reason that Trump may not do particularly well appealing the New York verdict on a jury unanimity question, Cannon is, I think, sort of, as Ben says, flat wrong on this issue here. But it will be interesting to see all of the ways that this plays out.
And Ben, Trump had a new motion to dismiss filed this week in the classified documents case. Can you talk about what he is saying that the special counsel's office did in this motion?
So this is the big Mar-a-Lago search motion. It turns out, if you read this brief, that everything about the Mar-a-Lago search was the most illegal ever. Everyone's saying it. Everyone knows it. And this is basically, the Mar-a-Lago search was so bad, Judge Cannon, that please throw out the entire case, or at least suppress all the evidence. The government has not yet responded to this brief. I'm sure, based on her past handling of matters, that Judge Cannon will probably want to hold a hearing about it, because she's holding hearings on just about every motion. So I expect that the circumstances of the Mar-a-Lago raid will be ventilated at great length in arguments. The other matter to keep an eye on, as we discussed last week with Roger, is that these various motions to dismiss on the basis that the special counsel was illegally appointed are coming up for argument, I believe, end of next week and beginning of the following week. And that is really worth watching, because Judge Cannon's clearly thinking about this, because she gave the amicus brief writers, including Josh Blackman, argument time. In fact, I believe that both of the people who've been given argument time have either appeared on the Lawfare podcast or written for Lawfare. But she's given them argument time, which means, she's taking it at least seriously enough to want to hear from not one, but two amici on this. I will say what I said the last time this came up, which is I really hope she grants this motion and dismisses the case on this basis, because it is a matter in which there's a lot of clear law. It's a matter in which, while the 11th Circuit has never had anything to say about it, a lot of other courts have. And I think granting a motion to dismiss would allow the special counsel to take her up to the 11th Circuit on a very clean basis. And this one is one in which there's no underlying facts to argue about. It's a pure question of law. The circumstances of Jack Smith's appointment are not in dispute. And so I actually think it would be a very attractive thing. And I suspect, although I certainly do not speak for him, that Jack Smith is secretly hoping to lose this motion at the district court level, because it would be a really clean way to go up to the 11th Circuit and say, will somebody, say a 3-judge panel, rid me of this meddlesome judge?
And then before we turn to audience questions, Quinta or Ben, any final thoughts on, or final thoughts for this segment on the classified documents case and what Judge Cannon has been up to?
I think we've said it all. I don't have anything more.
I am super excited about the hearing on next Friday and Monday and the following Monday, because I am not going to be there, and Anna Bauer will be there. But I just think, having Anna stuck in Fort Pierce, Florida over a weekend, you all should be very nice to Anna, because she's doing this for you.
And I think on that note, we're now going to turn to audience questions. Oh, and also to say, if you want to read any of these orders or motions that we've mentioned in the classified documents case, you can find all of them on Lawfare's Mar-a-Lago docket watch, which can be found on our website.
And Anna Hickey,
now,
who manages Lawfare's Mar-a-Lago docket?
Our wonderful associate editor Heyman Han edits it and then, manages it, and I help out as needed.
Oh, that was not the answer I was expecting. I was expecting the answer, a group of us do, including myself.
Oh, that's fair. But Jacob, you have the first question for today.
Thanks. It sounds like prior to sentencing, Judge Merchan can request a psychological evaluation of Trump. If he does, will we know that that's happened? And is it at all likely to happen?
Quinta, do you have thoughts on this?
I don't know about this aspect of New York criminal practice, but I would suspect that the justice will not ask for that, just because he's been very measured in his approach to Trump thus far, and that seems like a escalation.
I would also point out that that is usually done at the request of one side or the other, and for very different reasons, neither side is going to do that, to request that. So I suppose it's theoretically possible. The district court has all kinds of inherent authority to manage his caseload, but it's not the kind of thing you usually do on a classy felony, apropos of nothing.
Right. Richard, you're up next. You have to unmute yourself.
There we go. Thank you. If the special counsel seeks a writ of mandamus from the 11th Circuit, what can we expect the process to look like? How many judges would be hearing the petition, and how would they be selected? And does it make any sense to speculate about a timetable for a decision once any sort of hearings are scheduled? What do we know about the relative speed with which the 11th Circuit tends to dispatch such matters?
Quinta, I can take this, or you can take it as you like.
No, go ahead. This is not something that I've been focusing on particularly.
So a mandamus petition, as a general matter, they usually take place, or they often take place. They're not that common, but they generally take place on an emergency basis. And they usually happen because there's no general appeal allowed. There sometimes is a time constraint associated with them. The district court has ordered something outrageous and you have to get it corrected, and it's not subject to interlocutory appeal, for example. That's not always the case, but it's often the case. So most courts, most of the time, will calibrate the speed of a mandamus or an emergency action to how greatly they perceive the emergency to be one. When Judge Cannon did her first ruling on after the search of Mar-a-Lago, the 11th Circuit acted quite quickly. I forget how many weeks it was, but you had the mandamus petition go up and it was assigned to a panel, and then they held oral arguments within, I don't know, it was within a few weeks, and then they issued a ruling very quickly. So I don't think there's the issue for the special counsel is finding a situation in which there is a winning mandamus order, because you don't want to go up to the 11th Circuit and lose. As to the appointments, as to the composition of the panel, it's randomly assigned 3-judge panel. The 11th Circuit is a conservative court, but which is one reason, they're not going to bring before the 11th Circuit something that isn't beyond ideological differences wrong on her part. And so this is one of the reasons I would say it would be a gift to them if she would just throw the case out on one of these motions to dismiss, because then you don't need a mandamus. You can just go up on a regular appeal.
And Simon from Montreal, you have the next question.
Thank you, Anna. Speaking of cases in New York State, I was wondering, what's the state of play in the other New York State case, the one which found that the Trump organization had overvalued their real estate assets and a very large fine was imposed? Last I heard, the Trump organization had posted bond pending appeal, but the state was evidently questioning the validity of the bond. Has anything formal been decided about whether or not the bond is reasonable, and also pertaining to the value of the bond that they have to post?
So I think you are conflating two cases here, but I'm not certain about this. To be perfectly clear, I have not followed the civil cases or the Trump organization criminal case all that closely. But I believe you are conflating a criminal case against the Trump organization with one of the civil cases in which Trump had a $450 million judgment against him, and was posted a bond that had some degree of question as to its validity. My impression is that at this point, all of the questions of the validity of the bond, which in any event was lowered, have been resolved, and the questions these will be lengthy appeals, both at the intermediate appellate court level and then at the New York Court of Appeals. And so I would say do not hold your breath for a judgment quickly in those cases.
All right, Michael, you have 2 questions. So let's take them one at a time. If you can give us your first question.
Sure. Question the first, as a general matter, why are convicts not usually permitted counsel during an interview with their probation officer?
That is a great question. Quinta, do you have thoughts on it?
The criminal legal system is typically stacked against defendants is my best answer for you. I don't have any more specificity beyond that.
Fair enough. Okay.
I also don't know the answer to that question. I will say that my impression is that, nothing you say, these are not situations in which you're in jeopardy as a result of things you say. You've already, been convicted and whatever. And you are, I believe, but I don't know the answer to that question, nor do I know whether that's similar in other jurisdictions.
Okay. Second question is, let's suppose the former guy gets probation in lieu of jail time. Are those probation terms likely to include a search condition? And what does a parole search look like when the probationer's home is a skiff?
Look, nobody knows the answer to this question. And look, most people who are on probation can't leave the state either. And it's not a good enough answer to say, yeah, but I have a rally in Wisconsin. And so if you imagine that he is that he's subject to supervised release, and on probation, Justice Merchan would have to figure out how to apply that to somebody who's actively running for president. And I don't think we have any analog for that. And he would have to make it up in consultation with laws that clearly were not written with this question in mind. And he would have to use the discretion that and I don't know how much discretion he has on that point, and the equitable powers of the court, and he'd make something up and Trump would appeal it, and you would have a kind of fight over that, much as you did over the gag order. That's the best I can do, but I'm sure he is thinking about that question. Let's go one over the course of this month. That's one of the things he's working on.
All right, and now anonymous attendee has a question. Why isn't the part of Judge Cannon's ruling that requires unanimity on means something that can be appealed, or is it? And then Josh Knight had a similar question, which is, did Judge Cannon decide something that could be appealed? So why isn't that specific part of her order appealable, or is it, and would Jack Smith go that route?
So it is not appealable, at least not on an interlocutory basis. And now you could file a writ of mandamus that says she has now announced that she's planning to do this. She hasn't done it yet, by the way. She's just said, by the way, I will instruct the jury to do this. So you could take her up on that basis and say, she's announced her intent to do something that's flatly unlawful, assuming that I'm right that it is flatly unlawful. And I think the other side would argue, no, she actually hasn't. She's said she's planning to do that, and at the point at which she does it, you can file a writ of mandamus then. And I suspect that the standards for a writ of mandamus are sufficiently high that Trump would win on that basis. And that's why you want to be extremely careful when you're Jack Smith about what you take her up on, because you don't want to swing at the king and miss, or the queen.
All right, and then going to John Hawkinson, your question.
Hello,
Thanks.
John.
Hey, Ben. So as we learn more about how the justice system works or doesn't in Fulton County, including holding attorneys in contempt in the Young Thug trial, the Wright Street jail, Nathan Wade's questionable judgment as evinced in a CNN interview last night, et cetera, the moral case for allowing Trumpy defendants to remove their cases from state court to federal court seems to strengthen. And it sure seems like they don't have such a great system there. But the moral case is not the legal case. But is there any thought that the shifting of the moral Overton window affects the likelihood of Mark Meadows prevailing somehow in his removal case at the Supreme Court, where he's, I guess, got an extension on filing cert?
Quinta, do you have thoughts on this?
My instinct is no. I confess I haven't looked at it particularly closely. Um, state courts are state courts. It seems like the Young Thug case is sort of uniquely dysfunctional, and I'll leave listeners to look up on their own what is happening there because I honestly am so confused that I can't possibly explain it. But I agree that it does not speak well of the Fulton County Prosecutor's Office. But, this prosecutor's office the DA's office is dysfunctional, is not a legal reason for removal. I don't know, Ben, if you disagree.
I don't, although I do think, so first of all, as you may remember, John, I actually thought the legal case for removal was much better than the district judge did. And I thought the case for removal of the thing to federal court made a lot of sense. And so I would not be sorry if Mark Meadows were to prevail at the Supreme Court level. I think the argument that this thing should be in federal court is a fairly strong one. Meadows has hired not just good, but superlative appellate counsel in Paul Clement. And I'm sure that his cert petition will be as good as it can possibly be. He has really, really first-rate counsel. And so I think the Supreme Court will get the benefit of really, really excellent briefing. And by the way, Meadows was very well represented at the lower court as well, although not by Clement. And so, look, I think I agree with John that the optics of all kinds of things that we've learned about the Fulton County system, from wads of cash to young slime life to conditions at the Fulton County Jail, which we certainly knew about before. None of it puts the system in a flattering light, but ultimately Quinta is right. That's not the basis on which this is going to be decided. It may be a factor that affects the optics of the way the justices look at it. And I don't know. I was surprised that the district court treated the matter the way it did, to be honest. I thought the case for removal was better than Judge Jones, I believe, gave it credit for. And the 11th Circuit, in a fit of inane textualism, rejected the appeal on what I think is the stupidest basis imaginable. And so I don't feel like any court has looked at this through the lens that I would want a court to look at it. And I very rarely think the Supreme Court is, I don't usually look forward to Supreme Court adjudication, but if Clement and company could get the Supreme Court to take a good look at this question, I'm not sure that would be a bad thing at all. Interestingly, it wouldn't affect Trump, who has lapsed in his deadline to apply for a Sikh removal lapsed. And so he's waived any claim to removal that he may have had. But I don't know, that's just one citizen's opinion.
Quinta, any thoughts or move into the next question?
No, I think I've said what I have to say.
Jeff asks, a recent Lawfare article argues the due process principle that no person is allowed to be a judge in their own cause makes a presidential self-pardon unconstitutional. Does that principle also infer Supreme Court justices should not be allowed to judge for themselves if they violated judicial ethics standards? What should accountability look like from a balance of powers perspective? And for those in the chat, I'll drop the Lawfare article on presidential self-pardons shortly. Ben or Quinta, any thoughts?
Yeah, I mean, look, I'll take let me back up. I think that the question that is worth asking here is, who is the adjudicator of these questions? And the answer is the Supreme Court. So the answer that we're going to get is that the justices can do whatever they want. Whatever, legal principle you might want to argue applies to it. I certainly agree that it is unseemly for the justices to not have to abide by any standards other than the ones that they sort of deign to acknowledge. But the fact of the matter is that nobody is going to prevent them from doing whatever they want. And it's not really justiciable in the same way that a self-pardon would be. So I think the fact of the matter is that there's not much that's going to happen here unless Congress, decides to defund the Supreme Court, or give them only, $1 a year or something like that until they implement an ethics program. I don't know, Ben, what do you think?
So look, I think the problem here, I don't think fundamentally is systemic. I think the problem here fundamentally is personal and relates to the capacity of shame of individuals. There was a time, and it was not that long ago, when a $20,000 gift from a rich person to Abe Fortas caused Abe Fortas to resign from the court after facing potential impeachment. And now we have a justice who has taken apparently $4 million in gifts and seems utterly ashamed by it. And we have another justice who seems content to say that the flying of flags from his house is merely an expression of his wife's constitutional and property rights. And I don't know that I have a problem with the 200-year plus of practice that Supreme Court justices decide for themselves when to recuse. And I don't know that I have a problem with the performance on that score by 7 justices of the Supreme Court. And I do think that we have a problem with 2 justices who seem to not, and I don't really know how to say this politely, who don't seem to be concerned about optics problems with their own behavior, and don't seem to see why anybody would have cause to question whether this has something to do with the substance of their rulings. Judicial ethics are somewhat beyond Lawfare's purview, and so I have not had a lot to say on this subject, but I don't know that I think the right answer to it is to tear up the way we've done judicial ethics for 200 years. It may be that the right answer to this is to have justices on the Supreme Court who care about ethical behavior. And interestingly, when in all the Sturm und Drang over judicial nominations, asking them their intent about things like gifts and optics and flying flags never plays much of a role in I don't think, for example, in all the questions that Clarence Thomas got asked at his hearings, I don't think anybody asked, what would you do if a very rich guy tried to gift you a giant RV? And maybe we need to spend a little bit more time on those questions and make sure people go through. I mean, obviously, we're not going to predict the RVing habit specifically, but maybe we need to talk to people. By the way, there's no reason why they can't answer those questions. They're not cases that come before them. But how cautious would you be, right? And there are people on courts. One with whom I'm very familiar was Merrick Garland, who were exceedingly cautious. And there are people who are dramatically less so. And maybe that's something the Senate needs to pay attention to at the front end.
Right. Quinta, any more thoughts on judicial ethics before we turn to our next question?
I'll stick with what I've said.
So Ian McKellar asks, given that Trump was convicted of false business records, if he had simply paid Stormy Daniels to keep quiet from his own funds, would he have committed a crime?
Not unless he covered it up later. That's,
Yeah,
that's as
there we
simple
go.
as that.
Now, there is an interesting question whether he would have had to disclose that as a contribution to his own campaign. But
I think the answer to that is no.
I think that's right.
Under federal campaign finance law. So it's really just a question of if he'd, correctly indicated in the Trump organization record somehow if that was needed to be done. Or I mean, if he took it just out of his own bank account.
His own bank account is a Trump organization.
Oh, is it? You're right. You're right.
That's what
that's part of the problem.
That's part of the problem. And so
right, but if he'd just done it and then said, yes, this is a payment to Stormy Daniels, it would not be a crime. Right.
All right. Penelope asks, last week, Roger or Ben commented that Judge Cannon likely is confident she can draft instructions assuring a not guilty verdict. I realize a judge has tremendous influence on the jury, but how are the instructions that slanted possible given the facts of the case?
Right. So just to be clear, I don't think either Roger or I said they would guarantee, right, but put a significant thumb on the scale. And the answer really is that, first of all, it's very hard to appeal it, right? So Roger did an article about the rare cases in which jury instructions have been so outrageous that the Justice Department has had to seek a writ of mandamus to get them corrected. But there's no other mechanism, right? Because once you are at the jury instruction stage, an acquittal is not appealable, right? And so let's say you give outrageous instructions and the government can't appeal it or doesn't get a writ of mandamus, which is, of course, very, very difficult to get. There's no remedy at that stage. And so this is the reason that we actually count on district judges to be honest. Judges have very different ideologies, but good district judges are all much more similar than different. And, when you're in front of, I could rattle off a list of, the good district judges in this area. And, we are blessed in the District of Columbia with a really, really fine federal bench. And, things are a little different if you're in so-and-so's court than in so-and-so's court. And some of that has a little bit of a political inflection, particularly on questions of law. But on questions of fairness, it really doesn't. And particularly in criminal cases. And you can go to the district bench here, and it's very hard to tell who the Republican and who the Democratic appointees are. Easier at the circuit court level, because there you're dealing with more theoretical questions a lot of the time. Look, if it gets as far as Judge Cannon actually issuing jury instructions, this case is in trouble. Now, that doesn't mean it's going to Penelope is correct that the evidence here is so strong that you could get a conviction anyway. You could actually have very rigorous, less than entirely lawful jury instructions, and the government could sort of say, instead of trying to go to the circuit over this, let's just roll the dice because we can actually argue this matter under this standard. But I don't think they want to get that far. I think they want to I think they want to well, they will want, I think, to get the case out of her court before it gets that far.
And then Stacy asks, I would love to follow Lawfare's live tweet threads when there are trials or other events, but doesn't want to have a Twitter account. Will you please consider posting those threads to Blue Sky in addition to Twitter? And I can take this one really quickly. I want to say, first of all, Blue Sky is just not as conducive to live tweeting as Twitter is because of how their platform is set up. Additionally, people like Anna Bauer and Tyler Bryan live tweet live at different court events. And so to get, consistent live tweeting, you can't really toggle between platforms because you need to be constantly doing it. I think Anna and Tyler at one point were averaging like 5 tweets every couple of minutes. It was, their words per minute was getting pretty fast and impressive. And so there's just a couple barriers to doing that, but we try to have other versions of our court dispatches, which you can find on, the New York dispatches section of Lawfare's website or the post-court live stream dispatches. Ben, any other?
Yeah, just we did during Roger's live tweeting of the Proud Boys and Oath Keepers cases, we did have a live blog on the site that simply replicated all of those tweets, notwithstanding the programming help of one John Hawkinson, who wrote us a little bot to try to automate it. It was extremely time consuming to maintain for a bunch of people. I do think the next time we do this, we didn't realize when we set this up for the current, the New York trial, just how important the live tweeting was going to be. And it was just something we tried and people loved it. When we do this again, we will definitely replicate the live tweeting, and we will certainly figure out a way for it to live on the site as well. And it may be that we will just revive John Hawkinson's bot and give it a little bit of human supervision, but we will make a point of having it available to people on the site. I share your desire not to have a Twitter account, which I effectuated by, as you may know, getting myself kicked off of Twitter. And I don't think you should have to be on Twitter in order to get Lawfare's content.
And just one more note on Twitter, it is a little bit harder to get tweets embedded on our website because of changes to the way Twitter is structured and how they interact with third-party sites. So it's a little bit more difficult to have like embedded tweets or software that would hypothetically post a tweet on multiple platforms at once. So, working with the software that we have. Nathan asks, recently, we've seen the increased use of the concept of lawfare by various officials in the media in relation to the various trials against Trump. And then they give some examples, including Mike Allen at Axios termed lawfare as political warfare involving the courts. Is there anything you would like to say or to clarify these interpretations, if not aspersions, in the public sphere of the term lawfare?
Bring it on, guys. I've said this before. I love it every time Donald Trump talks about lawfare, because people then Google the word lawfare. And if you Google the word lawfare, what comes up? Us. And so I am for everybody using lawfare as a term of endearment, a term of opprobrium, as a term of to cast aspersions, to yell at us, to praise us, whatever. Just use the term, sprinkle it, lawfare, randomly into your speech. Talk about it, lawfare, lawfare, lawfare over dinner. Use it profligately and out of context. Just get people Googling the word lawfare.
And then Anonymous attendee asks a question. I think, Quinta, you'll be the best equipped to answer this. I know this question may be passé pending appeals, but I'm still confused about the object offense. As I currently understand it, the business record falsification is the misdemeanor. Its object offense is election fraud. But the election fraud also needs an object offense, sub-object offense, which is any of tax fraud, FECA violation, or some third option. I always forget. If this is a correct summary, why is the intermediate election fraud offense necessary? Why not just go directly from the business record falsification to one of the 3 sub-object offenses? Follow-up question, what possible fact pattern would support only a misdemeanor charge of falsification of business records? That is, how could one falsify business records that wasn't in furtherance of some other crime?
So the answer to the first question is that originally prosecutors actually did set it up this way. There's a piece that I have that's called, I think, Charting Bragg's Legal Theory or something like that, that kind of maps this out. But originally there were multiple different object offenses, including all of the offenses that are now the unlawful means under the election conspiracy offense. Prosecutors eventually ended up settling only on the election conspiracy offense. For what reasons, it's not totally clear. And so that is why the sort of structure, the charging structure is set up in that way. To the second question about, what are the circumstances? I confess I did not look deeply at the misdemeanor prosecutions for this in the case law, but you can imagine, if you paid attention to the Trump trial, I think it was pretty clear that the prosecutors had him banged to rights on the records falsification. And really the only question was whether there was sufficient evidence to prove beyond a reasonable doubt the intent to commit the additional crime. So, in that instance, you could say if you have someone who falsified a record in some way, but you're not sure that you can prove the crime that you believe that they actually committed, then, go ahead, slap them with the misdemeanor. There you go. Much easier to prosecute. There's also the fact that sometimes these offenses seem to be, these cases seem to be charged with, well, actually, sorry, strike that. I've tangled myself up. But I think that's kind of the long and the short of it. In the same way that, the sort of analogous crime here is burglary. You could say that you have a crime where why do you have burglary in the first degree, or burglary in the second degree if you have burglary in the first degree, which is, burglary with an intent to commit another crime. Maybe sometimes you're not sure what the other crime is and you just want to be able to prosecute the burglary.
Next up, Josh asks, there have been reports that Trump said he had not turned in all 3 guns that he had New York permits for, and possession of a gun violated his conditions of release in other jurisdictions. Anything to do with that? Any expected consequences for the retention of guns by the former president?
So again, these are not matters that courts will look into on their own. If federal prosecutors or Georgia prosecutors, although that case is stayed, wanted to bring this matter to the attention of a court, that could be the basis of a revocation of supervised release. I think that's unlikely. I don't think, in fact, any of these prosecutors want to lock up Donald Trump or have his bail revoked. But if having a gun unlawfully is in fact independently a federal offense, actually.
As we all learned with the Hunter Biden case.
Yeah, although that was charged as a lie on the form. But if if you're a felon in possession of a firearm, that's a crime. And so, I do suspect that there's probably somebody who's kind of scratching their head in the Justice Department and saying, hey, is that something we should look into?
And then Andrew gets our final question of this week. Hindsight is 2020 now that they've lost the stay motion, but what, if any, was the strategic or tactical reason for the non-appealing defendants in Fulton County to not join Roman's appeal in the Fani Willis disqualification order?
Yeah, I can take that. I think the answer to that is that if you are not confident that the matter is going to succeed, there's risk to having a completely poisonous relationship with the DA's office. And I do think particularly Ashley Merchant, but some of the others who were behind this motion as well, they have burned their relationship with the DA's office, and that can have negative implications for their client. It can have negative implications for their practice otherwise. This thing got really, really personal. And so if you're a defendant who maybe is thinks, well, heck, if Ashley Merchant wants to take out the DA and we can get a free ride off of that, because if the case falls apart, it falls apart against us too. So why should we join it? We can be a kind of freeloader. But one thing you do give up is the ability to appeal it if it gets you half of what you want, but not the other half, right? So they kneecapped Nathan Wade. They made Fani Willis look really bad. They got the words odor of mendacity into an opinion from Boy Wonder, all of which was from their point of view, a job well done, but they didn't get the DA disqualified. And so they want to appeal that. And if you're not party to the original motion, you don't get to be party to that appeal. And so I think that's the explanation, that there was a certain amount of free riding going on. But now they're going to pay, or they may pay the price for that.
All right, well, we will finish up a little bit early today. Quinta, Jurecic, Benjamin Wittes, thank you so much for joining us. And thank you for watching on Zoom and YouTube. If you are joining us on YouTube and you want to be able to submit questions to the panelists and watch this live stream without ads, you can do so by becoming a Lawfare Material supporter at lawfaremedia.org/support. We will see you back here next week.